I'm Mike Doyle from Falmouth, Maine. I was approached by a senior officer of a national company about an insured leverage bank deposit. I checked it out with another senior officer in the same company who also verified it was real and that he was involved in the project. This turned out to be a Ponzi scheme. When I was contacted by the state regulators in September of '98, I went to my longtime lawyer, Ralph Dyer, Esquire. My partner, Dennis Dankos, went to his lawyer, Peter DeTroy, Esquire. Jointly, we took advice from both lawyers and acted on their recommendations. The most crucial series of memos came from Dyer in October and November of 1998, referring to DeTroy's plan. In that plan were 5 steps lettered A through E. Letter C, DeTroy states, tell the investors the plan is working. This was 2 to 3 months after Dyer and DeTroy later claimed that they had advised me, not in writing, that this was a Ponzi back in the previous September. I was then referred by DeTroy to his friend Rick Byrne, who wanted $15,000 up front. I paid him $13,000, and then he wanted me to plead guilty and take an 18-month sentence. I then changed lawyers to David Van Dyke from Berman and Simmons, who over a period of a year got me to the point where I had to plead guilty that day or be ready to start a trial in 2 days. I knew Van Dyke wasn't ready to start a trial, so he said, plead guilty on this one technical point, and we'll fight it out in the law court. During this time, I found a tape recording of a call with business department regulator named Steve Diamond, a Stanford Law grad, which proved that Diamond's notes of the call were a lie when he proffered that testimony. My previous guilty plea was vacated. During the next 6 months, David Van Dyke got me a trial date where he once again wasn't ready for trial and said he would lose any case at that time and my sentence would be between 2 and 2.5 years. Or I could plead guilty for the second time and serve less than a year. At the time, I had a 10-year-old son at home, and I did this and served 8 months and 3 weeks. 5 months after that, 5 months after I got out of jail or prison, my court-appointed lawyer received a letter from the AG's office stating that they were disclosing that DeTroy was representing David Van Dyke while Van Dyke was convincing me to plead guilty so Van Dyke wouldn't have to cross-examine his own defense lawyer. Van Dyke was actually being sued for malpractice, and Peter DeTroy was the witness-in-chief against me by the state, while also serving as co-counsel with my lawyer, Ralph Dyer. So it was an extreme conflict of interest that the state perpetrated on me and used that leverage to get me to plead guilty for something that they had actually told me to do. It was so bad that after all this happened, the fee arbitration panel reduced David Van Dyke's fee by almost $13,000 because he had been found billing me for activity that had taken place in this case prior to him meeting me. So 6 months later, during the post-conviction review hearing, the court ignored their own expert witness that they were paying for that outlined all the ways that David Van Dyke's conduct was driven by self-protection and against my interest to the point I had to sign a release from suing him to get Van Dyke to testify to what he had done to me. The lawyer testifying to this conduct, Mary Davis, Esquire, had only seen this done one time before, and it also involved attorney Van Dyke.